my God. It's not, oh, it's muted now, I think, right?
Yeah.
I think so. Okay, everybody. So today, thank you. It's good to see a lot of old friends, familiar faces and names. So we will, let's see, I work at NYLAG, and we have 300 attorneys and paralegals at NYLAG and financial counselors. So check out our nylag.org website to see what all we do besides our small little Evelyn Frank program, which is one unit at NYLAG. So let's see, I want to just get rid of some of these things so I can see. So we're going to start with, budget cuts. That's what we're going to spend most of our time on. Things not that were passed this year, because nothing new was passed this year, fortunately. Usually, I know Laura reminded me, I usually come in April and speak, and usually we're announcing new cuts. There's nothing new this year, but there's lots of bad stuff that was passed last year and in prior years that they are now implementing. And people, I know, have a lot of questions about these things, especially the Lookback, which we'll be talking about. We want to spend a little time talking about COVID and how that impacts getting Medicaid. And there's a lot of other things going on that are on the bottom of the screen that we're not going to have time to get to, but there are some links there to get to them. So let's see. I'm having a little trouble with. Okay, so they're implementing some things now that were passed in law a number of years ago, but they're just going into effect now. So the first one went into effect this last December, so just a few months ago. And that is that now people are no longer able to change MLTC plans anytime they want. Starting last December 1st, if someone newly enrolled in a plan or changed plans, they do have a 90-day grace period where they can change plans for any reason. But after that, for 9 months, they cannot change plans unless they have good cause. And this is called the lock-in. It only applies to the traditional MLTC plans, not to PACE and not to Medicaid Advantage Plus. They can still change plans at any time. Now, there's a big warning sign here, though. And we've always said this, that when you change plans, a lot of clients think that this plan wouldn't give them an increase in hours, so they're going to change plans. Or this plan no longer contracts with their home care vendor. And that means they lost their aid, so they want to change plans, okay? Now, that last reason, the aide is no longer working with the plan, is good cause. You'd still be allowed to change plans for that reason. But beware that these are all considered voluntary changes. And you don't have continuity of care rights. We also call them transition rights, which means that the new plan does not have to give you the same hours that your old plan gave you. They may give that to you, but they don't have to. And if they don't, you have a right to challenge that in an appeal, but your status is that you're requesting it as an increase. And that gives you a much lower rights and less advantage than if a plan is trying to reduce your hours. So we don't encourage people to voluntarily change plans anyway, because especially when they have high hours of care, because they really could risk losing, 24-hour care or 12-hour day care. Now, just to put that into context, an involuntary plan change, you do have transition rights. And so examples of involuntary changes are that your plan closes. I think many people know GuildNet closed, ICS closed. There are always plan closings. And we have a whole article about plan closings and people's rights at the link at the bottom here. Or let's say you got immediate needs services from CASA. And then after 120 days, New York Medicaid Choice sends you a notice saying, okay, now you have to pick an MLTC plan. And if you don't pick one, we're assigning you to one. So that's an involuntary change. And there's one other situation where somebody did not have Medicare, so they were in a mainstream managed care plan. And then when they got Medicare, they were required to switch to an MLTC plan or a Medicaid Advantage Plus plan. So these are all examples of involuntary changes. And in these cases, the new plan is required to continue the same plan of care. And that's the same number of hours of home care or adult daycare, when that is opening up for 90 days. And in one situation where a plan closed 120 days. So in a voluntary plan change, you do not have those rights. So that's important to keep in mind. And after that transition period, the plan may reduce hours only for cause. If your medical condition improved, if your social circumstances change, for example, your daughter is no longer working and decided she'll take care of you full time, so you need few hours of home care, or they made a mistake in the original authorization, which is very, very limited. Now, big caution, one of the things that might be coming down the pike is that the state has proposed new regulations that would really change these rules and make it much easier for a plan to reduce hours after one of these mandatory transition periods. So like after a plan closing, after that 90-day transition period or 120-day transition period, the new plan could just say, well, we think ICS or GuildNet gave you hours that were more than medically necessary. Under our standards, you only qualify for, X amount of care. And the state wants to let them do that. And that's a proposed regulation, which NYLAG and other organizations are, adamantly opposing. But I expect it will probably be put on the books. So that's something that we have to watch for. Another change that was passed several years ago is taking people out of MLTC after they've been in a nursing home for 3 months and after they're already on institutional Medicaid. So, since 2015, I know I've spoken to this group for all these years, and I talked to you back in 2015 when they did the carve-in. They said, okay, nursing home services are now part of MLTC, and you'll stay in a plan when you're in a nursing home. Well, a few years later, they decided that was a mistake. And now they're carving nursing home care out of MLTC and saying MLTC will only cover nursing home care for a few months. And let's see.
I sent it to everybody. I sent it to everybody that's on that email.
So now, sorry, that got just a little distracted here. So now if you're in the nursing home for 3 months, which includes your Medicare period, that includes the time that Medicare is paying for rehab, you can be disenrolled from the plan. And advocates are very concerned that this would mean that it will be much harder to get out of the nursing home by, because now you'll have to start over, enrolling in an MLTC plan, getting a conflict-free assessment. You know, the enrollment's only the first of the month. So, you know, there's many delays there. It will take much longer than just to have your existing plan start up home care again. So you can prevent someone from being disenrolled. And the way to do that is, well, there's 2 ways. One, they will get a notice. Now, everybody who's in this category gets a notice. You can see a copy of the notice at this link. And the notice tells them you have a right to request a fair hearing or call New York Medicaid Choice to request an assessment. And if you do either of those things, you will not be disenrolled from the MLTC plan. But very few people have done this. I think they gave us numbers out of 20,000 MLTC members who have been disenrolled so far, just since last August. In 1 month, it was only 4 people who requested a hearing out of thousands who got this notice. So people are either happy to be in the nursing home, or what we're afraid of is that the letters are just going to the resident in the nursing home who might not be getting the letter from the nursing home. The nursing homes are, you know, obviously quite strapped with COVID, and many have dementia, or many can't read English, or, you know, for many reasons, they're not understanding the letter. So advocates have been asking the state, you know, you have to send copies of these letters to the person's family member or their advocate or their social worker. So what they've said is that they will only send it to someone who is listed as authorized representative on the Medicaid application. And we said, well, that's silly, because the Medicaid application is often done by the nursing home because they want to get paid, and the family member advocate might not even be involved in that. And they said, too bad, that's what we're using. So here's a suggestion of how a family member or social worker could be listed, so that if the client does get this notice to be disenrolled, they will get a copy, is to send this form. There's a link at the bottom of the slide to, in New York City, you'd send it to HRA, and we have some suggested fax numbers here. And definitely call ICANN, the state's ombuds program for MLTC, if there are issues with this. If someone was disenrolled who should not have been disenrolled, because they're really actively trying to go home. And we've had, you know, terrible cases of this. I mean, the plan is already set. The plan that we want a hearing or we want an appeal to get the plan to provide 24-hour care, it's all set. And then they're disenrolled from the plan. So these things can be, you know, obviously very difficult. So don't, you know, use these contacts. All right. Now we're going to talk about the look back, which is, I know, a lot on people's minds. Want to share what I know so far. And new information comes out all the time. Like just at the end of last month, a new proposal was sent by the state to CMS, the Federal Medicaid Agency, giving us more detail about how they're going to implement the look back. And you can see that for yourself here at this link. So this is very, very fresh, okay? So the first detail they shared is news that the look back will now start January 1st, 2022. All right, now that's news. You're the first to hear this in a group setting. You may have known that the date was originally, I think, last April, then July, and now it's officially January 1st, 2022. Now, here at the bottom of the slide, the reason it's been delayed is because there are federal protections because of the pandemic. Something called the maintenance of effort requirements, or MOE, that say states are getting a lot of extra money from the federal government for their Medicaid programs. Like New York's getting like several $1 billion. But there are strings on that. And one of the strings is states can't restrict Medicaid eligibility during the pandemic. So that's why they weren't allowed to implement the look back all this time. And by setting the date of January 1st of next year, they're betting that the pandemic emergency will be declared over by then. So stay tuned, okay? None of us know. We all know the pandemic is not over. We sure hope it's over by then, but no one knows now. So stay tuned. That still might be rolled back further, all right? But right now, let's assume that that's the date so you can understand what it's going to look like, all right? So just a little refresher, what is the look back? The look back is a period of time before the application. And the application has to include copies of all financial records back to a certain date, the beginning of the look back period, which is October 1st, 2020. And those records are required for both the applicant and their spouse. So at first, the look back period will be 14 months, because if it's starting January 1st, 2022, and looks back to October 1st, 2020, that's 14 months. Then in every month, they're going to add a month onto that until it is 30 months or 2.5 years. So that will happen in, I think, 2023 or 24. No, I forget. But it's 30 months from October 1st, 2020. Oh, so it's 2023. I don't know. The math is hard, but you get the idea. Now, what happens if they find a transfer of assets in that look back period? Then there's a transfer penalty. And if that transfer does not fall into an exception, then there's a transfer penalty, which means Medicaid will not pay for community-based long-term care services for the penalty period. And I'll show you more about what that means. So this only applies to new applications filed after January 1st, 2022, and requests to increase coverage to cover community-based long-term care. So I'll explain that in just a minute. But what that means is anyone who applies between now and who applied in the past or who applies anytime in 2021 will not have to do the look back. So even if they made a transfer of assets after October 1st, 2020, there's no look back, not on a renewal. And that's they made clear in this new posting they made just last month. So just to put this into context, I think everyone is familiar with that there's always been a look back for nursing home care. And in nursing home context, it's 5 years that the look back is required. And that's under federal law. All states have to do it. But the federal law gives states an option to do it for community-based long-term care. And New York never did it. They always thought, no, we really want to encourage community-based long-term care and we want to make it available. So we're not doing a look back. But last year, they enacted the look back in the law. But it can't be implemented until they get approval from the federal government about its procedures. They have to do regulations in addition to COVID. So for all these reasons, it's delayed. Now, the look back is only for long-term care services. It's not for, if you apply for Medicaid, it's not for hospital care. It's not for acute or primary care. All right, so it's only for long-term care, and we'll look at a list of how they're defining long-term care. So it's all home care services, personal care, CDPAP, private duty nursing. It's also the assisted living program or ALP program. It's adult day health care. And all MLTC enrollment, including Medicaid Advantage Plus and PACE plans, and certified home health agency services. Now, in this latest posting that they just posted last month, excuse me, excuse me. Allergies, excuse me. They clarified that, oh dear, I can't get my, excuse me. They clarified for CHA, that it should not apply to the first 29 days of CHA services. So if you get out of the hospital, obviously very frequently you need CHA services, or out of rehab. Now we know Medicare often pays for these, but not always, because the Medicare rules are stricter for CHA, for certified home health services, than Medicaid. They require that strict homebound requirements, and they require daily skilled nursing need, which Medicaid does not require. So sometimes people need Medicaid to cover the home health aid services or a visiting nurse, and not Medicare. So it looks like from this latest proposal that they're saying for 29 days, you won't need a look back, but we're going to ask them to clarify that because it's not clear. There is no look back required if you're seeking these waivers: the nursing home transition and diversion waiver, the traumatic brain injury waiver, or the waiver for people with developmental disabilities from OPWDD. Now, I have a question about, well, when you're applying for Medicaid, how would you show that you're seeking one of these programs, because you can't enroll in these waivers until you have Medicaid. So how would they know? So that's a question I don't know the answer to yet. And anyone who doesn't have Medicare, who's in a mainstream plan, and these are also people without a spend down, which is, the majority of Medicaid recipients are in mainstream plans. They're families and kids and young singles and, everybody who got Medicaid through the Affordable Care Act. They don't have to do the look back. And as I said before, if you only need Medicaid for acute or primary care or hospital services, there's no look back. So I mentioned this before, some people are grandfathered in. So anyone who applies for Medicaid with community-based long-term care before next January does not have to do the look back. And this they made clear with this recent submission in March. It was not that clear before. So how do you make sure, and they said specifically, it doesn't matter if you're not yet receiving these services. So we're very glad they clarified that, because let's say someone applies in November, but they haven't done the conflict free yet, or they're not in the plan yet, or it's not approved yet. These were all questions, and now they've answered that one question definitively, I think in a good way, that as long as you get that application in. Now, how do you make sure that will be true? You have to get that application in with the supplement A, and you should verify assets instead of do attestation. So attestation is what's been allowed during the pandemic. If we don't get to it at the end of the slide deck, there are slides about the special pandemic rules that allowed you to attest on the application without attaching a copy of your bank statement that proves that your assets are under 15,900, right? So if it were me, I would say, if you've transferred assets since October 1st, 2020, and you're nervous about the look back, I would definitely not attest. I would file that application before January 1st and verify your assets with Sup A, and just make it really clear you're applying for Medicaid coverage with community-based long-term care, and not leave any question marks about it. Now, reminder, if you're on our mailing list, you got an alert about this. If you're not on our mailing list, you should join it, and I'll put a link in the chat at the end, or send it out. So there's a new Supplement A for Medicaid applications that started this past January. So here's a link to it. And the reason they made this change is that they were preparing for the look back. And the new Sup A has a space for a spouse to sign, not just for the client to sign. And this is a requirement of the look back, because now the spouse has to verify assets too, even if they're doing a spousal refusal, and even if they're not applying. So that's a big change, and that's something that you have to wrap your arms around to really. That's a big change, because I think people are used to just doing that spousal refusal form, and the spouse is out of the picture, and you don't really worry about their income and your assets. But I'll just give you an example. In a minute of why the spouse does have to sign. So throw out your new old Supplement A forms, use this form, and make sure the spouse signs it in addition to the client. Now, there is some gray area still about people who should be grandfathered in, and we've asked the state to look at them. So let's say you have people who had Medicaid, have Medicaid now in 2020, but they get Medicare, say next February, right? They turn 65, or they're 24 months of receiving disability passes. And now they have to transition to what we consider regular Medicaid under the non-Magi rules. They can't be under the Affordable Care Act anymore. So they really have to reapply for Medicaid. So we said, well, they shouldn't have to do a look back because they're already on Medicaid. They're not reapplying, they're just being redetermined. And it's not clear yet what they're saying. One thing that they acknowledged from our previous comments is we have people all the time who have to reapply for Medicaid because something happened in the renewal process, right? Those annual renewals that during the pandemic are basically suspended. I hope you all know that your clients receive the renewals, but if they don't get them in, nothing can happen to them. Their Medicaid has to be renewed by HRA anyway. And those slides are at the end of the slide deck. But once the pandemic's over, it's going to happen again. And we're going to see people cut off from Medicaid who have to reapply. And we think they shouldn't have to go through the look back. This was just a glitch, a procedural glitch. So we'll see. We'll see where that comes out. As I said before, it's being phased in. So here we go. Here's the answer to that question that I couldn't do the math on. It'll be phased in by April 2023. I still don't know if that's right. 20 months. Yeah, that's right. So, there's been a lot of buzz and questions. I've gotten so many questions, I think, and everybody has. If my client transferred assets after October 1st of 2020, what's safe for them to do? And now we have more definitive answer. It is safe for them to apply before January 1st, 2022. There's no look back, even if they transferred those assets after October 1st. All right, so that's really can answer that question. Now, just about these married applicants, as I said, you have to include all assets for the look back period for the spouse as well as the applicant, which is a big change. Now let's look at this example, and this will illustrate to you why this is true, even though we still have spousal refusal. So we represent Pat, she's the applicant, okay? Her spouse, Randy, transferred $50,000 during the look back period. Randy still has $200,000 in assets. So Randy can still do a spousal refusal. That's still allowed. And so that $200,000 won't be counted against Pat for the asset test. Now, of course, we have to advise Randy that they can be sued for support by HRA or their local DSS for refusing, but they're willing to take that risk. But the $50,000 transfer does count and will give Pat a transfer penalty. So that's how the spousal refusal still exists, but it's apples and oranges. The the transfer penalty will affect the applicant, even if the transfer was made by the spouse. And that's why the look back records have to include the spouse's records. So how long is the transfer penalty? It's the same. If you know how it's done for nursing homes, it's exactly the same. You take the total amount that was transferred throughout the look back period by both the applicant and their spouse. Let's say that amount is $39,000. You divide it by the regional nursing home rate, which is updated every year by the state. And this year in New York City, it's 13,000 and change. And you come out, and I'm rounding it here, for 3 months. So it means this is the number of months that Medicaid will not pay for nursing home care and now will not pay for home care or the assisted living program. Are there exceptions to the transfer penalty? Yes, and they are the same as they are for nursing home care. So just very briefly, transfers to a spouse or a disabled child have no penalty. And transfer to a supplemental needs trust for a disabled person under 65 have no penalty. If you're transferring Holocaust restitution or another exempt asset, there's no penalty, because when you transfer an asset that's exempt, there can't be a penalty, because if you kept it, it would be allowed. So if you transfer it, it's still allowed. There are some other exceptions, which, you know, this requires its own training. So here's a brief list, a very general list. As you know, these rules are complicated. Transfer was made exclusively for a purpose other than to qualify for Medicaid long-term care. So you have a young, healthy client who had a stroke at age 40, and now they need Medicaid for long-term care. And they just paid for their kids' college, right? So who they're not legally responsible for. So that could be considered a gift, but they had no idea that they would be needing long-term care. Transfer the home is really up in the air. There's a big disagreement going on between the Bar Association that represents, you know, the elderly and the State Department of Health. The State Department of Health is saying the same rules apply that apply in the nursing home. And the Bar Association and NYLAG is saying, well, that doesn't make sense, because someone going to a nursing home, they're moving into the nursing home. That's what institutional Medicaid is. It's about permanent residence. And that means they no longer live at home. So it makes sense to say, if they still own their home or they transfer their home, that should have a penalty. But if you're living in your home getting home care, the home is exempt while you're living in it. Now, if you're single, there is an equity limit, and that's here, $906,000. But if you're married or have a minor or disabled child, there's no equity limit. So let's say the home is under the equity limit and you transfer it to your daughter while you're living there and apply for home care, and she's not disabled. Yeah, the proposal that DOH has submitted to CMS in the last couple weeks says that will have a penalty. That will have a transfer penalty. And that's true even if the daughter moved in with you and lived with you for 2 years and took care of you before you applied for home care. And some of you may have heard of this caregiver child exception, which applies for nursing home care. If a child moved in, took care of you for 2 years before you went into a nursing home and you transferred the home to them, that's an exempt transfer. The state's saying that will not apply in the home setting because the federal law defines it to say the child moved in for 2 years before you went into a nursing home. Since you're not going into a nursing home, there's no exception. I mean, obviously that makes absolutely no sense. So homes, you know, you don't want to mess with this. You got to refer your clients to an elder law attorney. And right now, none of them know either because we're all puzzling over this. How to what to make of this. But it's going to sift out at some point. There's an exception for the transfer penalty that, let's say you transferred the money to your daughter who spent it. You know, she was laid off, her husband was laid off, they had to use it for their, you know, to support their family, and it's gone, money's gone. And so there are exceptions that if denying you home care now or denying you nursing home care would deprive you of medical care that would endanger your health or life, or deprive you of food, clothing, or shelter, and you're unable to have the resources returned despite your best efforts, then that exception could be granted. But the state has defined this in the nursing home context so strictly that the state policy, the state regulations say that's only true if you have no spend down. If your income is above the Medicaid limit, which is only $884 a month, by definition, you cannot qualify for this undue hardship exception, which basically means, you know, very few people would ever meet this exception. So NYLAG and the bar have all really lobbied the state on changing this. And the last they posted in that March posting was, we're thinking about it. So we will see. We're going to lobby further. Comments are due on this last posting in May. So we'll see. Obviously, that's really important. We're really concerned about delays. This is really going to delay applications. I mean, I think many of you see how long it takes for Medicaid to be approved anyway. And you add initially 14-month look back, eventually 30-month look back. It's really going to delay things. Now, you know, one thing is that there is this thing called the asset verification system that HRA has only just implemented, also, you know, very late. They were supposed to implement it like quite a few years ago, and they just got around to it. So I'm hoping that when they come out with procedures, they will say that you don't have to submit all your bank statements, because bank records they can get electronically through this AVS, asset verification system. But they can't get investment account records. They can't get like IRA records. They can only get like regular bank records and I guess real estate records. So for a lot of people who only have a bank account and nothing else, it might mean that they won't have to do the look back. When you're advising them, you probably still want to ask them to show you the records to make sure there's no transfers, and so you can address any questions that will arise. But as far as documentation, I'm hoping that that will reduce the burden on our clients. But a lot of people do have investment accounts. They have an IRA in an investment account. They have cash value of life insurance, all of that. Well, that's always had to be provided. So, and immediate need applications are supposed to be approved in 12 days. So how is that possible with this? And the state just says, yeah, the HRA has to do it. They got to do it. Well, we know that they can't do it. Even now, it's a big challenge for them to approve these so quickly. So that's a big concern. Pool trusts, big concern. Will they still be allowed? And why is it even a question? It's a question because under federal law, there's a transfer penalty on transfers of income, not just on transfers of assets. And when you're over 65, a transfer into a pool trust is not an exempt transfer. When you're under 65, it's fine. But many of us who work with the elderly, almost all of our clients are 65 or older. So again, the state bar is taking the lead on this and opposing this, trying to give them, authority for why they should still allow use of pool trusts. So we have to wait and see. I think that they will end up allowing it, but I think what it looks like they're leaning to is requiring that you never carry a balance in that account, in the pool trust account, that you have to, the money has to come in and it's got to go out in expenses. It can't accumulate. Now, even before, if it accumulated and you died, you lost the money. The money just stayed in the pool trust. So people have always had an incentive not to let their funds build up in a pool trust. But now it might be required to spend it. And people who own homes, who have irregular expenses like property taxes, that I understand many counties only allow them to be paid quarterly. You don't even have an option of paying them monthly. So how, or insurance, or, the roof repair that only happens once every few years, and you build up some money to make those repairs. So, there's going to be a lot of development of how pool trusts are handled. I'm hopeful that they'll still be allowed in for the routine ways, but I think that there'll be some limits put on. So one piece of good news is that we were very worried about this, that when the penalty period would begin, because in a nursing home, it works out pretty well, because the rule is that the penalty begins the first day the person is receiving services that Medicaid would pay for, except that there's a transfer penalty. So in a nursing home, when you apply, you're receiving services. So even if the application takes forever to be approved, it will be retroactive back to when you were admitted to the nursing home. So let's say you have a 10-month penalty, but it takes 10 months for the Medicaid application to be processed. And you knew that you'd have a 10-month penalty, and the money the family's paying with the transferred assets for your nursing home care. So the 10 months began in the month you were admitted, and now 10 months later, when the Medicaid application is approved, the penalty's over, and now Medicaid will pay. So that works out pretty well. But in home care, you can't be receiving services that Medicaid would pay for, because you're not even allowed to privately pay for MLTC or CDPAP or even personal care. It's a creature of Medicaid, the personal care program. Yes, there are licensed home care service agencies that you can pay from, but it's not the Medicaid personal care service officially. So the state has done a good thing, and they're saying they're going to let a doctor sign a form that you'll submit with the application saying this person needs home care. And that would qualify you to start the penalty running, to say that the penalty would, you'd otherwise be receiving Medicaid home care. So that's a good thing. We'll see how that develops. All right, so other changes. So they are raising the bar of who is eligible for home care. That, you know, now, as long as you need assistance with ADLs, activities of daily living at all, even one ADL, you can qualify for MLTC, which you can get from MLTC, or you can get immediate need from CASA, or if you're in hospice, you can get home care from CASA, or you can get it from a mainstream plan. And even if you don't have any ADLs, it's okay. There's still a very small program called the housekeeping program that you can get 8 hours a week of housekeeping assistance from HRA, from CASA. So, but that's ending, all right? So now you have to have 3 ADLs to qualify for MLTC or immediate need or home care through CASA if you're exempt from MLTC. The only exception is if you have dementia or an Alzheimer's diagnosis, and then you can qualify by needing supervision with 2 ADLs. Now, whenever this goes into effect, which we don't know when, I don't know when, it'll be sometime this year or next year. Anyone who's already receiving these services will be grandfathered in. All right, so it will only apply to new people getting home care services after whatever the effective date is. Now, what are the ADLs? They're saying they're going to use the UAS assessment to identify the ADLs, which is fine, except that we do have some concerns. They're not counting IADLs at all, which are the housekeeping services. They're not clearly counting incontinence care, and they're not counting transfer other than reasons of toileting. But leaving out housekeeping is a big concern. Doesn't play any role in deciding, do you need home care? And you will no longer be able to apply to HRA for housekeeping services. People who are getting them, that's at 8 hours a week maximum of care. With the instrumental ADLs, IADLs, they will be grandfathered in, and there's less than 700 people getting these services in all of New York City. But what's going to happen to those people? Some of you I know work for case management agencies that administer ISEP, or there's going to be huge pressure on ISEP to take those clients, but they don't have capacity. They already have waiting lists. So it's a really bad policy. It's eliminating an important preventive service, but that's what they're doing. You have to need physical assistance with the ADLs if you don't have dementia. And this is the scale on the UAS, the Uniform Assessment System tool that nurses use, just so you see where on the scale you have to fall. For the 3 ADLs, you have to need this limited assistance, which is defined as guided maneuvering of limbs and physical guidance without taking weight. And it's not clear to me whether that includes something like contact guarding, where the aide is sort of hovering, but not actually physically touching the client. If that's only supervision, then that is not going to cut it for the 3 ADLs unless you have dementia. So it's very strict. Big concern is that, how about people who are blind? You know, they need supervision with ADLs. They might not need hands-on physical assistance, but they will not get home care because they need physical assistance with 3 ADLs. So that's, so we think this is all illegal, that it discriminates based on diagnosis. But this is what's on the books, and this is what they're planning on repealing. Who knows? There might be a lawsuit about it. We'll have to see. And there's always been, I think every time I've spoken to this group, I've reminded you that, that supervision is only covered by Medicaid when it's supervisory, like queuing assistance with an ADL. In characterizing the client's needs, you never want to just say they need safety monitoring or supervision. You always want to point out, well, what do they need supervision with? They need queuing to safely toilet, queuing to safely ambulate. So it has to be connected to an ADL, and that's been true for a long time. All right. There's a lot on this slide, but this is this new assessment system that the state is going to start doing. And it gives a huge new role to Maximus, which we know is New York Medicaid Choice in New York State. So we're all familiar with the conflict-free assessment that the New York Medicaid Choice nurses do. That assessment is now going to be the only nurse assessment. The MLTC plan or HRA will no longer do a separate nursing assessment. So that's the one thing that sort of makes sense. Like, why have 2 assessments, two 4-hour assessments for every new MLTC enrollee? It just doesn't make any sense. But that's about the only place that it makes sense, because they're adding on an entirely new, what they're calling independent practitioner panel, which is a doctor's exam or a physician's assistant or nurse practitioner, all from New York Medicaid Choice. This is going to be for every person trying to enroll in an MLTC plan, and for every other assessment, for their annual assessments. It will no longer be just a UAS, a nurse's assessment. It will be a nurse's assessment plus this medical exam every year. Now, if you're a new enrollee, you have both of these things. Then the plan or HRA, if you're applying to HRA for immediate need, decide how much care you need. They still develop the care plan. But if that care plan, in their view, is for more than 12 hours a day, they then have to refer you to this high need panel. They're calling the IRP, the Independent Review Panel, again, by New York Medicaid Choice, which decides, is the proposed plan of care safe? Now, we have all sorts of concerns about this, which you can read in our 30 pages of comments on all of this. There's links elsewhere here. So all of this has to be done. Now, this won't have to be done every year once you already go through it. Like, let's say you have 24-hour care. and you get that, and then this is approved through this, the next year you won't have to go through this high need panel again. But everybody seeking 24-hour care for the first time is going to have to go through that. They're really pushing telehealth for all of this. We have big concerns about that. We're all for telehealth. It's been wonderful through the pandemic, but it's also had its limits. And to say that all of these, could be done by telehealth, many of our clients just don't have either the technology or the physical or cognitive capacity to use telehealth. This is the state's own graph, which you can look at once you get your own slides of how this will all work. And lots of concerns about delays in all this, big delays, and how long this is all going to take. Just want to quickly talk about, I know we're almost, these COVID protections. So no one should have their Medicaid cut off. For the last year, since March 18th, 2020, if your client's Medicaid is cut off and it wasn't their choice, request a fair hearing right away, and you can contact our program. The email address is right on the front. Not me personally, but our intake for assistance. It's no one's Medicaid should be cut off, even if they don't submit their renewal. Their Medicaid should be extended. If they pay in their spend down just for 1 month, they should get 6 months of coverage. So these are all, you can also now fax Medicaid applications. Here's the public e-fax number. If some of you are authorized submitters and can do it through the CREP unit, you can submit pooled trust to the spend down unit. And I talked about how you can attest now instead of verifying income and assets. So these are all these easements, which there are links to see for yourself. Fair hearings are all done by phone. And there's a number of other things. But I want to just see if there are probably some questions. Oh dear. No,
yes, we do have some questions in the chat.
Valerie. Okay.
I can queue them up for you if you like. And
okay,
Michelle?
Yeah, that's great. Okay.
Terrific, thank you. The first question, Valerie, was if the patient is in the nursing home, would the notice be sent to the nursing home or to their home?
So they're using the address that's on the Medicaid application. So, if the nursing home, whoever did the Medicaid application, what did they list as the address? I mean, that's the question. So that's why we're suggesting that you prepare that form that I pointed out and just send it in and ask the nursing home to list their home address. I mean, it should be listing their home address on a Medicaid application if someone still has their home and they're expecting to go home. But, this is a problem. I mean, we have many people that the notice is going to them at the nursing home because that was the address listed on the Medicaid application.
Excellent, thank you so much. The next question is, just to clarify, October starts to look back on applications filed in January, but are applications completed between October and December not subject to it?
All right. We got to use years here, okay?
October starts, October 2021, I believe, starts the look back on applications filed in January, but are applications completed between October 2021 and December 2021 not subject to it?
All right, well, there's some incorrect information there, okay? So October 2020 is the date that we're looking at transfers made after October 1st, 2020. All right, that's the significance of October 1st, 2020. Did the person make a transfer after that date? Now, it only matters if the application is filed after January 1st, 2022. All right, so if someone applies between October and December of this year of 2021, there's no look back. It doesn't matter if they made a transfer, okay? So it doesn't matter if anyone made a transfer today, last October at all, and unless they apply after January 1st of next year, 2022. That's a really, I'm glad you asked that question because we really need people to understand that. So yes, if you transfer assets today, that is now like a prohibited transfer. But it won't matter unless if you get that application filed before the end of this year.
Excellent.
Okay.
Great answer.
And
Thank
that's
you.
new. We had heard it was April 1st, and then it was July 1st. So there's been so much. So we're sort of grateful that they've now clarified. No, it's next January. So applications filed this year have a free get out of jail free card. No transfer penalty, no look back.
Excellent. Thank you so much. So
Okay.
if a husband makes more than a wife with the spouse, well, one spouse makes more than the other spouse, would the other spouse still qualify?
Okay, well, there's no one size fits all. You have to, all right, we still have spousal refusal, okay? So, but like this is not a basic Medicaid course. Like you should really enroll in, you know, HRA gives Medicaid courses, CSS give Medicaid courses. That question shows me someone doesn't know some very basic Medicaid. So it's not a matter of someone having more income. It's a question of how much is the income? I mean, it's if their income is $10,000 a month, it's one thing. If it's $800 a month, the answer is different. So if the two spouses' income together is more than the Medicaid limit, which is roughly $1,200 a month, it goes up every year, so I don't remember, then we're talking about using spousal refusal. And also in MLTC, we have the spousal impoverishment protections. So, you know, those are really, really important. And I can just, you know, only make a pitch for, let's see, can you see my screen?
Mm-hmm. Yes.
Okay, so if you use our website, and I put the link in the chat. Oh, I also put a link in the chat for, very first link in the chat is for the new funeral reimbursement that's available from the federal government. Make sure your clients know if there was a funeral due to COVID for a loved one, they can request reimbursement. There's a link in the chat. But in our home care section, there's a section, Know Your Rights, Manage Long-Term Care Fact Sheets. And there's a lot of fact sheets here and special strategies on reducing the spend down. And this includes spousal impoverishment protections and some other things. So take a look at these. I got to it just Medicaid, home care, Know Your Rights. Okay.
Great. Excellent. Thank you so much.
Sure.
Do we have any updates on the MLTC cap rates and the CDPAP PMPM?
The cap rate. So you're talking about capitation rates.
Capitation rates, yeah.
I mean, those aren't publicly disclosed. So the only way to get those that I know of is through a Freedom of Information request. So the question is, how much are plans getting paid by the month? That's what the capitation rate is. I don't know. This is not public information, so I'm not privy to it.
Got it. Thank you very much. Great answer. MLTC plans often say that they do not authorize home care hours for supervision. It seems that this new law is allowing supervision. Is that correct?
No, it's not correct. So if we go back to...
Yeah, and while we're looking, I just want to say we are at 10:30, but we can continue for the question and answer. So we understand anyone who needs to get off right now. Thank you so much for attending. We will be sending out the PDF of the presentation, but for those who wish to stay, you know, Valerie will, continue to answer questions right now.
Okay, yeah, I can say about 10 more minutes. Okay.
Okay.
So I realize, I'm glad you asked that question, because this is the point I was trying to make, which is, it's a subtle point. So I realize that's why your question is very helpful. So it was this slide. You're right that Medicaid doesn't cover standalone supervision. Like, let's say someone, you know, the examples that they give is, you know, someone might leave the stove on because of dementia. And they say, we don't pay an aide to hang out in case you leave the stove on. That's pure supervision in their eyes. All right. But what they do cover is supervisory assistance with an ADL. Okay. So the person needs to be reminded to use their walker. They have the walker, but they forgot that they broke their hip, right? Because they have dementia. So supervisory assistance, you know, we have clients who get to the bathroom and don't know what to do because they have dementia. Woman doesn't know she's got to take down her pants. Okay, and she has to be talked through the whole process. Now take down your pants. Okay, now you're going to sit down. Here's a piece of toilet paper. Now you're going to wipe yourself. Forgive my being graphic, but this is what supervisory assistance is with toileting. The aide may not be laying a hand on the client. It's not physical, but that's what verbal cueing and prompting is. So that sort of supervision is covered by Medicaid because it is an assistance with an ADL. And on this continuum of assistance on the UAS, it would be shown as supervision, oversight, cueing. And yes, Medicaid does allow that for you have to be able to name the ADL. And you usually can, or IADL, okay? But in order to count towards this new minimum number of ADLs, you're only allowed to use supervision with an ADL if the person has dementia or Alzheimer's disease. Not if they're blind, not if they have a traumatic brain injury, not if they have a developmental disability. For any other disability other than dementia, you have to show they have 3 ADLs for which they need limited assistance, which is defined as this: physical guidance without taking weight. So I guess that would be, you know, your sort of, I think contact guarding would be in there. You're helping somebody with their walker, but giving them some support, holding on to their arm, say, okay? You're not weight bearing with them, but you're stabilizing them. So it's going to be important for those of you who are present at a UAS interview. You're going to be picturing this, that this is what the nurse is completing. And you're going to, if your client doesn't have dementia, you're going to want to be really making an argument, figuring out in advance which 3 ADLs do you want to make sure that she includes as needing limited assistance? So you have a game plan. Now, this is not starting yet, okay? This, we don't know when it's starting. They have to get it approved by the feds. They have to do regulations. They have to train all the CASA workers. They have to train. They have to hire New York Medicaid Choice. So there's a lot for them to do before it goes live. But I hope you can sort of see the difference between this supervision is connected to an ADL. All of these, if you look at it at UAS, this is under each ADL: toileting, ambulation, transfer. It's not just freestanding supervision. Okay. Hello?
Yes. Thank you so much. That's excellent. Appreciate it.
Okay.
Thank you so much.
All right.
The next question was to ask for clarification that the current rule, the impression was that the rule now was that the DSS worker needed to be open with the best budget, and that there was no longer a wait to enroll currently in the MLTC or waivered services.
Okay, let's see. I did not really follow that.
I didn't really follow that either. So I thought the question as it was asked is, I thought the rule now was that the DSS worker needed to be open with the best budget, and that there's no longer a wait for enrolling into the MLTC or waivered services. Okay, let's go on to the next question.
Yeah, I don't know.
Yeah, let's go on to the next question. I can't really.
Valerie, what I was asking is, we tell them we want spousal budgeting as they're open, because they can have it even before they're in the MLTCs or the NHTDs, the way the law is now.
No, unfortunately not. You can have it in immediate need.
Well, that's what we do usually.
Okay, all right. Immediate need is different than MLTC.
Yeah.
The law says you can use spousal impoverishment in the immediate need program, and you always want to ask for that. Unfortunately, if you're applying for Medicaid to enroll in an MLTC plan, you can't use spousal impoverishment budgeting in that at that time. You can't request a spousal impoverishment budgeting until they are actually enrolled in the plan. And if you look at our fact sheet on it, as I showed you where you can find it, you have to wait, enroll, and the minute after you enrolled, then you send in your request to rebudget. Okay, that's just how it is. It's stupid. I don't know why they did it that way. I know why they did it that way. They were afraid people are going to apply for Medicaid, use spousal impoverishment budgeting, which allows a couple to keep about $4,000 a month of income, right? No spend down. It's great, right? And then not enroll in an MLTC plan. That's what they were thinking. Because you apply for Medicaid, you say you're going to enroll in MLTC, but there's nothing that requires you to. They give you Medicaid with spousal, you're going to go get all your dental care, you go get dentures and eyeglasses, and as if people are going to have a party with their Medicaid card, right? But they didn't want that to happen, so they said no. We're not giving you spousal impoverishment budgeting until you show us you are enrolled in a plan. Then we will turn it on. So in MLTC, it's a two-step process.
All right, I think that all of the other questions were answered within the presentation. So yeah, and we're almost at the 10-minute mark. Was there anything else, Valerie, that you wanted to add?
I think someone asked a good question. How serious does the dementia need to be to count?
Okay.
I mean, I think that's a great question that I'd love to know the answer to. I mean, I think, one thing I didn't point out here is that like there's nowhere in here for an M11Q. There's nowhere in here that they're going to like consult with the doctor. So I think one of the things that we're going to be suggesting, as this is, this isn't ready for prime time yet, but that people still have their doctor like do a statement or fill out an M11Q anyway, and give it to that nurse at that assessment. I mean, maybe that we'll come up with a new form. We'll want, because the people who are going to be examining, just like the Maximus nurse, are not people who know your client, So we're not doctors, but we know our clients much better than they do in just a, one-shot assessment. So I think some of the prep we're all going to be doing is to line up that evidence, get a good doctor statement, listing the diagnoses, listening to history, listening to everything, and here, nurse, this is for your assessment, and that's, I think, and it's going to explain the extent of assistance with the ADLs, and that way, at least there'll be some input from someone who knows the client. Look, the dementia has to be severe enough to require assistance with 2 ADLs. I mean, that's the standard. If it doesn't, I mean, we all know dementia can be a very long path or it could be a very short path, depending on the type of disease, right? And in early stages, someone might not qualify. But at some point when they need assistance, supervisory assistance with 2 ADLs, they qualify.
Okay, very good.
So please, everyone, look at our website. Okay, I'm just gonna one more time just show you, because I mean I'm very proud of if you go to our homepage. So when you just go on these news articles, I just updated this yesterday. With the new Lookback, there's always an article here with updates about the Medicaid cuts. You can always get to our past newsletters here. And if you don't get it, sign up here. And the latest one has a lot of news. It just went out April 6th. Take a look at it, because there's more news than I could cover today. And then there's always an article about MLTC updates. And there's always a news article here with COVID-19 resources. All right. These are always on the homepage. And then, there's lots of other things. We're always trying to improve it, but it can be a little hard to navigate, I admit. But, if you spend some time with it, you can learn like to get to the home care articles here. Okay. So I hope you'll do that.
Okay. All right. Very good. So thank you so much, Valerie. We keep seeing in the chat, everybody saying this was amazing presentation.
Oh, good. I'm glad it was helpful. Yeah, it's really good to see everybody.
Yes, and we will be posting the PDF on the website and also sending it out. So thank you so much, everyone. And we look forward to see you May 20th for our next Physiaca meeting. Okay, all right.
Thank you, Valerie.
Bye-bye, everyone.
Bye.
All right, bye-bye.
Bye.
Laura?
Yeah, I'll call you. Yeah.